Hey everyone, welcome back to the channel. We've got absolutely massive breaking news in the California ammunition ban case that honestly might be the turning point we've been waiting for. What started as one court challenge has now exploded into a nationwide coalition fighting against California's unconstitutional ammunition restrictions. The Trump Department of Justice isn't just filing briefs anymore. They want to stand up and argue in court. 25 states have now joined the fight. This is unprecedented, and it could change everything. Let's break down what just happened. Before we dive in, make sure you hit that subscribe button and turn on notifications. This case is developing rapidly, and you're going to want to know the moment anything happens. Also, thumbs up this video to help it reach more people. The algorithm loves engagement, and we need to spread this information as widely as possible. Alright, let's talk about Rhode versus Bonta. For those who aren't familiar, this case challenges California's absurd ammunition regulations. We're talking about a system that requires background checks every single time you purchase ammunition. Not once, not annually, every single purchase. And each time, you have to pay a fee. California also prohibits residents from ordering ammunition online and having it shipped to their homes. You can't bring ammunition back across state lines without risking prosecution, and all of this is on top of California's 11% tax on firearms and ammunition, which is itself on top of already sky-high state and local taxes. Californians are literally being taxed and feed out of their constitutional rights. Now here's a serious question I want you to consider. What would you think if a state required you to ask permission and pay a fee every single time you wanted to exercise a constitutional right? Imagine needing government approval and paying a fee every time you wanted to speak freely, practice your religion, or vote. That's exactly what California is doing with the Second Amendment. And it gets worse. This permission system gets things wrong more than 10% of the time. That means 1 in every 10 transactions results in an erroneous denial. Law-abiding citizens who have every right to purchase ammunition are being rejected by a faulty system. And when the system fails, you're the one who gets punished. You're denied your purchase, you've wasted your time and money, and you have no immediate recourse. Let me be absolutely clear about something. You cannot meaningfully exercise the right to keep and bear arms without access to ammunition. This isn't debatable. Courts have affirmed it. History confirms it. A firearm without ammunition is just an expensive paperweight. The constitutional right becomes meaningless if you can't obtain the ammunition to make your firearm functional. California claims they have historical precedent for these restrictions, but they don't. There is no historical analog from the founding era or the 19th century that supports requiring background checks for every ammunition purchase. The Founding Fathers never contemplated such restrictions. Early Americans could freely purchase ammunition without government approval, registration, or fees. Now, earlier this week, I made a video about the Trump Department of Justice filing an amicus brief in support of Kim Rhode and the other plaintiffs in this case. That brief was incredibly powerful, laying out detailed constitutional arguments for why California's ammunition regulations violate the Second Amendment. It was already huge news that the federal government was weighing in on behalf of gun rights. But what just happened yesterday might be even bigger. The Department of Justice didn't just file their brief and walk away. They've now officially requested permission to participate in oral arguments. That's right, the DOJ wants to stand before the Ninth Circuit in bank panel and argue on behalf of the...
So the plaintiffs' attorneys have already agreed to give the DOJ 5 minutes of their argument time. California's attorneys have no objection. This shouldn't be controversial for the court to approve, since it doesn't add any time to the proceedings. The DOJ is simply using time already allocated to the plaintiffs. This is a rare and significant move. The federal government doesn't typically request to argue at the circuit court level, especially in state law challenges. The fact that they're doing so here demonstrates how important they consider this case to be. It also shows the Trump administration's commitment to defending Second Amendment rights. Having the DOJ argue could be a game changer. These are experienced federal attorneys who argue before appellate courts regularly. They bring the weight and credibility of the United States government, and they're making it clear to the Ninth Circuit that the federal government believes California's law is unconstitutional. But wait, there's more, and this might be just as big, if not bigger. A massive coalition of states has now filed an amicus brief in support of Rhode and the Second Amendment. Let me read you this list because it's absolutely stunning. The brief was filed by Ohio, Idaho, Alabama, Alaska, Arkansas, Florida, Georgia, Indiana, Iowa, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Nebraska, New Hampshire, North Dakota, South Carolina, South Dakota, Tennessee, Texas, Utah, Virginia, West Virginia, and Wyoming. That's 25 states. And on top of that, the Arizona state legislature has also joined in support of the plaintiffs. Think about what this means. This is nearly half the country standing up and telling California that their ammunition restrictions are unconstitutional. These aren't just gun rights organizations or individual activists. These are state governments representing millions of Americans formally telling the Ninth Circuit that California has gone too far. The brief these states filed lays out in detail why California's law violates the Second Amendment and why it must be struck down. They explain how the right to keep and bear arms necessarily includes the right to acquire ammunition. They point out the lack of any historical precedent for California's restrictions, and they emphasize how these regulations burden law-abiding citizens while doing nothing to enhance public safety. And that's not even all the support Rhode has received. The Second Amendment Foundation, the Citizens Committee for the Right to Keep and Bear Arms, and the Second Amendment Law Center have also filed an amicus brief supporting the plaintiffs. This is turning into a massive coalition of Second Amendment advocates, state governments, and now the federal government, all aligned against California's unconstitutional law. It's pretty much a majority of the country versus California at this point. The contrast couldn't be starker. On one side, you have California and a handful of other blue states trying to regulate the Second Amendment out of existence. On the other side, you have most of America saying enough is enough. This is really shaping up to be an extraordinary case. The level of support Rhode is receiving is unprecedented. The involvement of the Trump DOJ is unprecedented. The coalition of 25 states is unprecedented. All of this is happening in front of the Ninth Circuit en banc panel, which historically has been hostile to Second Amendment rights. Let me be honest with you, the Ninth Circuit en banc has never ruled in favor of a Second Amendment challenge, not once. They have a long, consistent track record of upholding gun control laws, no matter how unconstitutional they might be. They've ignored Supreme Court precedent from Heller, McDonald, and Bruen. They've twisted historical analogies beyond recognition. They've applied made-up standards that make it virtually impossible to strike down any gun law. But I'm starting to wonder if this could be the case that finally breaks through. The pressure on the Ninth Circuit is immense. The federal government is arguing against California's law. 25 states are saying it's unconstitutional. Multiple gun rights organizations are involved. The historical evidence overwhelmingly favors the plaintiffs, and the Supreme Court has already provided clear guidance through Bruen.
If the Ninth Circuit upholds California's ammunition restrictions in the face of all this opposition and evidence, it would be one of the most blatant examples of judicial activism we've ever seen. It would demonstrate complete contempt for Supreme Court precedent, and it would virtually guarantee Supreme Court review, which California desperately wants to avoid. The oral arguments are scheduled for March 23rd. That's when we'll see the DOJ, the plaintiffs' attorneys, and California's attorneys make their case before the full en banc panel. I'm planning to live stream the oral arguments so we can all watch together and discuss what's happening in real time. Make sure you have notifications turned on so you don't miss it. Here's what's at stake. If Rhode wins at the Ninth Circuit, California will have to completely dismantle its ammunition background check system. Californians will be able to order ammunition online and have it shipped to their doors. They won't need to pay fees and undergo background checks for every purchase. They'll be able to transport ammunition across state lines without fear of prosecution. But this case is about more than just California. A victory here would set a precedent that other circuits would have to respect. States like New York, New Jersey, Massachusetts, and others with similar restrictions would face immediate legal challenges. The right to acquire ammunition would be firmly established as part of the Second Amendment. On the other hand, if California wins, it gives states a blueprint for effectively nullifying the Second Amendment. Other states will copy California's model, creating more barriers, more fees, more delays, and more denials. The right to keep and bear arms becomes theoretical rather than practical. That's why this coalition of states is formed. They understand that if California can get away with this, other states will try the same thing. They're drawing a line and saying these restrictions go too far. The coming weeks are going to be critical. We're waiting for the court to approve the DOJ's request to argue. We're watching to see if any other states or organizations file additional briefs, and we're preparing for what could be one of the most important oral arguments in Second Amendment history. I want to stay optimistic. The level of support for Rhode is extraordinary. The legal arguments are strong. The historical evidence is clear. The Trump DOJ is committed. 25 states are standing up. All of this has to count for something. But we also need to be realistic. The Ninth Circuit has disappointed us many times before. They might do it again. That's why it's crucial that we stay engaged, stay informed, and stay ready to push this case to the Supreme Court if necessary. I'll be following every development in this case and bringing you updates as soon as they happen. Make sure you're subscribed with notifications on. Drop a comment below with your thoughts on this massive coalition forming against California. Hit that like button to help spread this information, and share this video with any gun owners who need to know what's happening. This could be the case that finally forces the Ninth Circuit to respect the Second Amendment. Let's keep our fingers crossed and stay engaged in this fight. Thanks for watching, and I'll see you in the next update.